I think courts are going to realize that when Congress enacted the Communications Act and overhauled it back in 1996, that they didn't intend to grant the FCC the kind of authority that it's claiming it has to impose such a broad regulatory mandate on telecommunications providers, on broadband companies. A key reason this rule is infirm is because the very harms that it purports to solve are essentially non-existent, and they haven't provided any clear evidence that these harms are ever going to come into play. If anything, as technology evolves, the competitive pressures that face broadband companies are going to become more intense, not less intense, which means that to the extent that it was ever possible for companies to engage in truly harmful conduct, it's going to become less and less possible for them to do so in the future. The examples trotted out by advocates of these rules are, first, very few. Second, they are largely incredibly weak. We're talking about things like text message blocking, which is in many respects a completely separate issue that was solved by the marketplace. The FCC is saying, well, we're supposed to promote competition among information services. This is a way to do that. The problem, of course, is they haven't made a compelling case why the rules they proposed would actually do anything to promote competition. They say that what they're doing is promoting open internet rules of the road, except when Congress passed the '96 Telecommunications Act, the rules of the road that it intended to create for the broadband market, which at that time was virtually unheard of, involved a deregulatory approach. They viewed openness as allowing experimentation, allowing competition, allowing consumer choice unfettered by regulatory diktat. So what the FCC is doing right now, in a one real sense, is a reversion back to the pre-'96 era, to the old school method of regulating telecommunications, where we're pretending that this monopoly exists and that market failure is rampant. When, of course, in reality, what we're seeing is innovation, competition, growth, a market that's working fairly well. This is what agencies do. They try to assert power, to make headlines, to look good politically, to give their thousands of bureaucrats something to do. The problem, of course, here is that we should have fewer bureaucrats, fewer regulators involved in micromanaging the information and telecommunications sector. But bureaucracies don't exist to shrink their power, they exist to maximize their power. So they try to interpret any statutory grant of authority, such as that which Congress granted them in '96 and originally in 1934, as broadly as possible. Fortunately, the courts have slapped down the FCC on a number of occasions, most recently, of course, in the Comcast decision. I believe that it's likely that the lawsuit currently pending against the FCC will result in yet another legal rejection by the courts. A statement to the FCC that its power is not unlimited, that it has finite and specific authority to do things that Congress said it could do, and that anything that it wants to do beyond that is going to have to get permission from our legislators. If this rule goes through, if the notion that the FCC can do whatever it wants to do, and as long as it has some nexus to the broadband world, it's okay, that really puts no meaningful constraints on the agency's authority, which is incredibly troubling to really anyone who cares about the rule of law, whether you come at this from the standpoint of someone on the left or on the right or the libertarian perspective.